again request all participants and fellow speakers to switch on their webcams throughout the session. I'd also like to request the participants to kindly keep a pen and a notepad handy in order if you want to take down anything important. So, good evening, ladies and gentlemen. I'm P. Shravan Kumar, the founder of SK Associates and Group, and I'm delighted to welcome you all to Conference 4.4, wherein we'll explore the topic legal consideration for forming a business partnership in collaboration with our brand partners, Symbiosis Center of Entrepreneurship and Innovation, Pune, SIES College of Management Studies, Navi Mumbai, BMS Institute of Technology and Management, Bangalore, Sanjeevani University, Kopargaon, Motibabu Institute of Technology, Bihar, Sanskriti University, Uttar Pradesh, SVKM's Usha Praveen Gandhi College, Mumbai, Sri Vishwakarma Skill University, Palwal, St. Paul's Institute of Professional Studies, Indore, Sri Ramakrishna Degree and PG College, Nandyal, TRC Mahavidyalaya, Barabanki, Sandeep University, Nashik, Maristella College, Vijayawada, Bombay College of Pharmacy, Navi Mumbai, KCES Jalgaon College, Jalgaon, Indus International University, Dehradun, and lastly, Valley State College, Chitwan, Nepal. We would also like to extend our thanks to our esteemed media partners, namely Hindu Chakra Media, Daily Hunt, Republic News India, Flipboard, RD Times In, Indian Bulletin, Indian Sentinel, Abhyuday Times, News Outlook, National Age, Metro City News, and Let India Shine for the collaboration, support, and helping us deliver the session on an international scale. Moving forward, we would also like to thank our legal partners, Advocate Ramashankar Tiwari from Allahabad High Court, Senior Advocate Shishir Kumar Saxena from Supreme Court of India, Advocate Balaratna Kumar from AP and Telangana High Court, Advocate Krishpriya Anthony from Kerala High Court, Advocate Vikas Kumar Dangi from Delhi and Haryana High Court, Advocate Kiran Rajendra Makhare from Maharashtra High Court, Advocate Agam Shah from Ahmedabad High Court, Advocate Anandar Biranwar from Karnataka High Court, and Senior Advocate Pramod Kumar Singh from Delhi and Patna High Court. We are honored to host a distinguished panel of accomplished experts, lawyers, legal advisors, startup mentors, and academicians today as our guest speakers. Their extensive expertise in business law and partnerships will provide you all with deep insights into the legal consideration essentials for forming a successful business partnership. By the end of today's conference, we hope you will gain valuable legal and strategic perspectives to guide your entrepreneurial journey.
Hello everyone, I'm Dia Pashpai, Shravan's co-host for Conference 4.4, and it's my pleasure to co-host this conference with Shravan sir. Sir, you are on mute.
Am I audible now, Ms. Bajpai?
Yes, you're audible now.
That's great. Before we delve into our topic for today, let me briefly introduce SK Associates and Group. SK Associates and Group is an ISO certified management consulting firm registered under MSMED Act 2006 with the Government of India. Our mission is to provide consulting services to aspiring student entrepreneurs globally, covering areas such as compliance, legal advisory, audit, operations, marketing, research and development, human capital, strategy, and operations. Our passion lies in helping these budding entrepreneurs bring their dreams to life and contribute to global economic growth.
At SK Associates and Group, we take pride in offering tailor-made solutions to our clients. Our team of transformational consultants have a deep-rooted passion for entrepreneurship, and they bring extensive experience and expertise to every project. Over the past 3 years, we have built a network of 5,000 individuals from 30 plus countries, representing diverse universities, industries, and functional roles.
Our ultimate goal is to assist 600 million youths in India by providing pro bono consulting services in areas such as strategy, operations, human capital, compliance, legal advisory, audits, R&D, taxation, and marketing. We also plan to invest 500 crores US dollars in their startups by 2035, creating more than 5,000 employment opportunities for startup experts, advisors, mentors, and research scholars. Our vision is to contribute to global economic growth by empowering the next generation of iconic organizations.
Uh, Collaboration and strategic alliances are key to achieving our mission. We are committed to promoting entrepreneurship development and community impact. With a focus on empowering students for global economic growth, we aim to partner with 1,000 plus universities and colleges by 2030, providing guidance and mentorship to students as they embark on the startup journeys.
The enthusiasm and interest we see among students for entrepreneurship nowadays is truly inspiring to hear. Startups have the potential to address critical social, economical, and geopolitical changes through innovative business models. By promoting sustainable entrepreneurship, we can drive positive change and create a brighter future for all of us. Entrepreneurs not only generate job opportunities but also stimulate business growth. We have witnessed remarkable success stories wherein entrepreneurs have tackled issues such as climate change, waste management, education, artificial intelligence, and many others.
Absolutely. Entrepreneurship is a catalyst for change and innovation. It is a powerful force that can reshape industries, transform lives, and make the world a better place. We are committed to supporting student entrepreneurs on their journey, equipping them with the tools, knowledge, and the next networks that they need.
At SK Associates and Group, we are immensely grateful for the dedicated support of our executive management team, including Ms. Vaishali Shri, Head of Human Resources, Ms. Tia Bajpai, Chief Strategic Alliance Advisor, Mr. Faiz Siddiqui, Public Relations Manager, Ms. Pooja Kumari, Organizational Development Coordinator, and Ms. Rima Kumari, our Operations Coordinator. The unwavering commitment has played a pivotal role in our growth and development. Thanks to their dedication, we can make a meaningful impact on the entrepreneurial ecosystem by inspiring, educating, and mentoring young individuals, encouraging them to pursue entrepreneurship instead of a corporate career. Now, before we dive into our discussions, let's take a moment to introduce our esteemed lineup of panelists and guest speakers for today and tap into the wealth of wisdom they bring to the table.
Our first speaker of the day, Ms. Ruchi Prajapati, is a seasoned legal professional and the founder of Moxilex Legal, an international law firm offering strategic legal solutions to businesses across the globe. As a business lawyer, intellectual property rights attorney, and business contract expert, she brings extensive experience in guiding companies through complex legal frameworks. Her expertise lies in corporate retainers, mergers and acquisitions, a real estate legal advisory, and high stakes legal negotiations. She currently serves as a trusted legal advisor to several corporations, helping them ensure compliance, protect intellectual property, and structure impactful business contracts. Her global perspective and practical insights make her a valuable voice on the legal considerations essential for forming a business partnership.
Our next speaker for the day is none other than Ms. Aarti Shekhawat, a dedicated legal professional currently practicing as a lawyer at Rajesh Ruhela and Associates. With over 3 years of experience at the District and Sessions Court in Jaipur, she has built a strong foundation in handling a diverse range of cases, including civil, criminal, family law, and other legal matters under Section 138 of the Negotiable Instruments Act. A practical courtroom experience and hands on approach to litigation have given her a valuable insight into the everyday legal challenges individuals and businesses face. Ms. Shekhawat brings a grounded and pragmatic perspective to the legal considerations involved in forming and sustaining business partnerships.
Next up, we have Mr. Nijat Shukurlu, a research analyst and legal professional currently associated with Six Degree Intelligence. He holds an LLM from the East China University of Political Science and Law and brings a diverse international legal background to the table. Mr. Shukurlu has gained valuable experience working with prominent Chinese firms such as the Hang Law Offices and Poison Global. He also served as a lawyer at the Ministry of Economy of the Republic of Azerbaijan for 3 years, where he played a key role in legal advisory and policy matters. His core areas of expertise include international investment law, business law, and corporate law, making his insights particularly relevant to anyone exploring the legal dimensions of forming and scaling business partnerships across borders.
Next up, we have none other than Advocate Gaurav Joshi, a senior intellectual property associate at Strat Juris Law Partners, with over 3 years of specialized experience in trademarks, copyrights, patents, and designs. Joshi ji has been instrumental in advising clients on IP creation, prosecution, and enforcement, both in India and internationally. Advocate Gaurav Joshi has a proven track record in handling complex legal matters such as bad faith registrations and cross border IP disputes. He regularly advises startups on building a strong IP foundation and also supports Fortune 500 companies across diverse industries like FMCG, healthcare, fashion, and chemicals. Enrolled with the Bar Council of Uttarakhand and a member of the International Trademark Association (INTA), he brings both depth and precision to the evolving landscape of intellectual property laws, making his insights invaluable to entrepreneurs and businessmen seeking to protect and monetize their innovations effectively. So, welcome everyone, and it's an honor to have you all with us. Your expertise adds a special dimension to our conference, making it a unique and insightful gathering indeed. Now, before we begin this conference, we would like to request all of our attendees and panelists for today to kindly switch on your respective webcams so that we can have a two-way interaction throughout the session. We would also like to inform all of you that our HR team will be conducting opinion polls in the chat box throughout the conference, and we request you all to actively participate in them in the chat itself. Now, moving ahead, I would like to invite our first speaker for today, Ms. Ruchi Prajapati, and request her to commence her speech and share her insights with all of us.
Thank you for inviting me as a guest speaker in this conference. First of all, good evening, everyone. We have all heard the phrase, two heads are better than one, but when it comes to the business, there's two heads without a legal plan is become two headaches, right? So I am Advocate Ruchi Prajapati, founder and lawyer of Moxilex Legal, and today I will walk you through the legal side of partnerships so your next big business idea does not end in a courtroom. My one storytelling here is Chai and Challenges. So, what is Chai and Challenges? A story of two friends in business. Raj and Amir had been best friends, and from since college, every evening they met at the favorite tea stall, sipping chai and dreaming big. One day, Raj said, "Why don't we open our own cafe?" One day Raj said that you are great with food and I am good with numbers. With a handshake and smile, Chai Junctions was born. The cafe did well, customers loved the vibe, and Raj handles finance and marketing, and Amir cooked delicious snacks, profits flowed, dreams grow. But they had no any written agreement. A few months in, Amir wanted to open second branch. Raj hesitated. He wanted to stabilize first. They argued. The question arose, who gets to advise? Who has the final say? Legal lesson number one, always draft a partnership agreement. It should clearly state roles, responsibilities, capital contributions, decision making rights, and profit sharing. One day, Raj took a business loan without informing Amir. The loan turned bad. The bank came knocking not just on Raj's door but also Amir's. Legal lesson number two here is in a general partnership, all partners have unlimited liability. If one partner makes a mistake, the others can be held legally and financially responsible for that. Amir decided he wanted out. He wrote a note and left his keys and walked away. Raj was shocked and confused. Legal lesson number three here is define an exit strategy in your agreement. Your agreement must include how a partner can leave, how their share will be settled, and what happens to the business. Raj approached one lawyer. She said this could have been avoided with a simple legal document. A partnership is a legal relationship. Without structure, it can collapse. Then, moral of this story is a business partnership is not just about friendship or trust. It's about partnership with the purpose. clarity, it's about commitment and legal protection. So legal considerations in every partnership is must have. My first point here is first things first. It means what? Choose the right structure. Let's say Ramesh and Suresh want to start a business of sweets. Everything is sweets in their business, but they have no written agreement. Until there are laws, one partner disappears. If they are formed LLP, limited liability partnership, the laws would have been limited to their agreed capital. So always ask what kind of partnerships fits your risk and vision. Next point is write it down or write it off. A business partnerships without agreement is like a house without foundation. In Surat, I saw a case where three cousins started a textile trading firm with no written agreement. 5 years later, it was turning into crores and crores. But one cousin felt left out of decisions. The result is what? A court battle, emotional breakdowns, and frozen bank accounts. Your partnership or LLP agreement must cover who brings how much capital, who does what is your profit sharing ratio, what if one partner wants to exit, who decides what and how. Think of it as your business planner. My second next point is protect your ideas. I mean to say intellectual property. Imagine you are starting a designer wear brand. You create a slogan, you create a tagline, designs, logo. 6 months later, your partner walks away and start a new brand using your designs and logo. It happens. We can see in market. IP must be registered and ownership clearly defined in the agreement. If your brand, software, or formula is your baby, protect it like one, right? My next point is confidentiality and non-compete a must. You taught your partner everything. Now they are your competitor. Without a non-compete clause, there are not much you can do. Add clear clause. Confidentiality during and after partnership. No competing business for X years in X area. Business trust is great, but legal protection is very smarter. My next point is have a plan B before starting your plan A. Let's say things don't work out in your plan A. You want to exit peacefully, but your partner refuses it. And now you are stuck. So your agreement should have exit procedures, buyout options, dispute resolutions by mediations, arbitrations, negotiations, and jurisdiction. Decide where legal issues will be resolved. It's like a will. You hope you won't need it, but you will be glad if it's there. My next point is stay compliant, stay safe. Depending on your business, register for PAN, GST, food license, export import card, a code shops and establishment license, and MSME certificates. And for LLP and companies, don't forget annual filings, right? Because ignorance is very expensive and penalties are really hard. Choose the right partnership structure. Before you shake hands, decide the legal form. We have three types of partnerships. General partnerships, in that equal responsibilities and liabilities. In LLP, limited liability and more structures. And if you choose private limited company with co-founders, shareholders, and directors, so for high growth ventures, each comes with different tax implications, legal liabilities, and compliance requirements. Next point is draft a legally sound partnership LLP agreement. This is your business prenup. It must clearly state profit sharing ratio, capital contributions, exit retirement or dissolution terms, conflict resolutions. Never rely on verbal promises. Put everything in writing form. Understand liability and risk sharing. Who is responsible for what? In general partnership, partners are personally liable. In LLP, liability is limited to your contributions, and if you are bringing in your name, network, or intellectual property, protect it legally. Intellectual property rights, it's define ownerships of your patents, trademarks, branding, logo, software designs, process. Regulatory compliances, I already told about license and all. Dispute resolution is very necessary. Disputes are common, but court battles are very expensive. I'm a lawyer, still I am say Court battles are very expensive and very time consuming. Include a clause for mediation and arbitration, define jurisdictions clearly, and avoid ambiguity. Confidentiality and non-compete clause. Then closing a successful partnership starts with clarity, commitment, and compliances. Legal planning is not just about protection, it's preparation for your growth. So before you go into business with someone, sit with a good lawyer, not just a good friend. So, to all future partners in the room, I say this: partnership is like a marriage. You have marriage certificate for prove your marriage. So, it needs a trust, but also it needs a contract. Don't just share profits, share responsibilities, share your rights, risk on paper. And speak to lawyer before speak to any investor. Because great business are not just built on ideas, they are built on strong legal foundations. So here, thank you, and I wish you all safe, successful partnerships in your business. And thank you so much, SK and ANG Group, for giving me the opportunity to share my opinion on the legal considerations of the business partnerships in Legal Conference 4.4. Thank you so much again.
Thank you, Ms. Ruchi Prajapati, for the wonderful speech. Please share your email address in the chat box. If any of our audience has any questions, they can reach out to you.
Thank you.
Moving ahead, let's welcome Ms. Aarti Shekhawat, and I request her to commence the speech.
Yeah. Until RTG joins, I guess we can have a question answer round with Ruchi ji, I guess, Ms. Bajpai.
Sure, sure.
Ruchi ji, am I audible?
Yes, yes, sir.
Sure. Would you like to take some questions from the audience?
Okay.
Sure. I would like to request the participants to unmute themselves and put their questions forth if you have any. Yeah, Harshit, Mehak, Ruchir, Natya, Rangshu, Farhan. Any questions on the topic? You can just unmute yourself and speak to Ruchi ji. No questions from the audience? Okay. Ruchi ji, I had a small question. Since in Indian laws, according to Indian laws, when we talk of partnerships, we form a limited liability partnership, right? But internationally, when we want to expand out a LLP or we want to go for a foreign expansion of a LLP, we need to rename it the entity type as a LLC, limited liability company. So could you please like explain the difference between these both?
In LLC, they like LLP. It is a limited liability partnership, and in LLC is limited liability company. Difference between both of this is in company they are provided partnership and private limited. We have in India private limited, public limited, and LLP. So they have only LLC. And in contributions and liability, risk and responsibilities are all depends on their contributions, capital contributions.
Okay, that was great actually. And that was great. Thank you. Another question I had
I
is
think there's
Ruchiji.
a question in the
Okay.
chat box as well.
Okay. I guess we have a question from the audience. Yeah. How LLP agreements are different from partnership agreement? Ruchiji? Yeah, Ruchi, you are on mute. If you can just unmute yourself.
Sorry, can you repeat the question?
Yeah. So Mr. CSP Doleshwar Rao from Calcutta writes, how LLP agreement is different from a partnership agreement.
LLP agreement is different from partnership agreement. As I told, general partnership is a different thing and LLP is different thing. Like in LLP, if you have contribute your capital 1 lakh or 2 lakh, then you have some percentage of amount of your liability. If their business is in risk or is in loss, is in profit. So it depends on your contributions. Where we move forward to the general partnership, you have to you have equal ratio with your partner, like 50-50%, 30-30%, depends on number of partners. So this is difference.
That's great. Now, my question was, Ruchi ji, assuming that most of the startups, that is 99% of startups nowadays, get incorporated in the form of a private limited company, right? But assuming that there is a solopreneur or someone who is not very sure that this startup idea would be a great success, so to mitigate risk, they start their company in a proprietorship format entity. And later on, after 2 to 3 years of operations, they wish to convert it into a private limited company. So, what would be the procedure of this conversion from a proprietorship to a private limited?
First of all, my suggestion here is, if you are a sole proprietor, then go with the sole proprietorship firm. In that, you have just want to get MSME or Udyam certificate or any other GST registration like that. And if you have to expand your business in entire India or beyond India, then you have to register your business in ROC, like private limited, with your director's details. Otherwise, for startup, I am giving advice for sole proprietorship. If you have a number of people like partners, then you go through the LLP or general partnerships, whichever is in you prefer for comfortable for your business.
That's great. That's great. Do we have any other questions from the audience? Anyone with questions, you may just raise your hands and ask. It's not important to be shy. So, yeah, we have a question from Yasin in the chat box if you would like to read it. Ruchi ji.
If an entrepreneurship Indian company is planning to provide their services in the US, what kind of registration process are they supposed to undergo with US government? Okay, you have to register your company in the US, in the US portal. Like in intellectual property, we want to expand your business or deliver, distribute your products in the USA market, then you have to register their USPTO office for trademark and copyright. So same thing here is, you have to register your company in USA.
So, yeah, I guess you got your answer, Yasin. Satisfactory. Register as in.
Register as an LLC.
So, I guess subsidiary registration is also important, right? Ruchi ji?
Yes.
Point here. Okay. I guess that will do for now, Ms. Bajpai. You may go ahead.
Sure. So next, let's welcome Mr. Nijat Shukuru, and I request him to comment his speech.
Good evening, everyone. I hope you can hear me clearly.
Yeah, you're audible,
Yes,
Mr.
yeah.
Yeah. Okay. First, I would like to pay my gratitude to the SK team for inviting me as a speaker for this event, and I wish good luck to all the other speakers. And yeah, I will be commenting. So I will present a presentation and I will talk about the topic. So let's go. Just a second. Oh, no. No, that's not it. I guess that will take a minute.
No, it's not visible, Najat.
Okay,
Try once
found it.
again. Almost came.
So is it clear, visible?
Yeah, now it's visible. Great. Perfect.
Yes.
All right, very nice. Okay, so today we'll talk about the foreign investment law and specifically the foreign direct investment law. And let's go. So our contents will be consisting of the introduction to FDI, like foreign direct investment, legal framework for governing FDI, key concepts on FDI law, investment incentives and protections, challenges in FDI regulations, dispute resolutions in foreign direct investment, and conclusion and Q&A session. Let's continue. So the first we will mention that what is the definition of the foreign direct investment and what kind of types there are in this trend. So as you can see in the text, which I have stated, FDI involves investment made by a firm or individual in one country into business interests located in another country. What does it mean? Let's say we have India and we have close countries like Bangladesh, right? And India, some Indian company like they are investing, let's say, $100 million to Bangladesh in the, let's say, in the agricultural matters. So they build a factory there. They employ people. They made the contracts and everything. And this is one of the which you can imagine this is the foreign direct investment. And of course, there are like importance is that it causes with the economic growth of the both side countries. So technology transfer happening, which is, let's say, India takes this technology to Bangladesh and makes and it concludes with the improvement of the Bangladesh technology and also economy. And of course, there are some new job places that are being opened in the country that are being invested. So which kind of types there are? We are talking about the first is the greenfield investment, starting from new venture from scratch. The one I was talking about is the greenfield investment. And brownfield investment is that acquiring or leasing the existing facilities. Let's say there's already the facility in Bangladesh and Indian company, they just buy that shares of the company. And the third one is also the merger and acquisitions, which is also showing itself as the also buying the shares and the share like taking some majority shareholders and so on. So with these forms, we are making the foreign direct investment to other countries. And what are the legal frameworks which are governing the FTIs? First, we need to talk about the domestic laws, which like the country that are being invested. The countries that are being invested, they have their domestic laws, how they are regulating the foreign direct investment when the foreign entities are investing their country. And of course, we have another matter, which is the international agreements. That consists of the bilateral investment treaties, multilateral treaties such as New York Convention, the ICSID Convention, and also the ACT, and the FTAs, which is the free trade agreements between the countries. And yeah, so on. Also BITs, like the bilateral investment treaties, they are, for me, then they are the most important part of the international agreements, because that is the main one that regulates the the foreign direct investment to the country. Let's continue. The key concepts in the FTI law for direct investment are the definition of foreign investor. My master thesis is about the definition of foreign investor, and I have made the research about that. So, which states that when you define foreign investor in your regulation, you need to be so precise. Otherwise, that will cause lots of problems for you, and if you have any cases in future, and that will make some troubles because of you that you didn't define the foreign investor properly in your regulations. The second matter is the ownership thresholds, which is we have in investment law 10% rule, which means, let's say, one company from other country, it invests in your country, and to call them you are a foreign investor, they need to have at least 10% shares of the local companies. Of course, it's not the same in everywhere in every country, but that's the generally accepted rule. And also the other one is the actually most important one is the national treatment and most favored nation treatment. What is national treatment? The national treatment is that you say the foreign investor that when you come to my country, make an investment, I will treat you that you are like my own investor. So there will be no difference, and there will be no the same rules, same regulations will be applied to you as well. And also, most favored nation treatment is that that was the national treatment. Like you say, foreign investor, you say it comes to your country, you tell them that okay, I will see no difference between you and my investors. But what is most favored nation treatment is that you say all the other countries that it doesn't matter if you're from Azerbaijan, Turkey, Russia, or Kazakhstan. I will see that I will treat all of you the same. Okay, so that's what the most favored nation treatment. The other important issue is the expropriation and compensation. What is an expropriation? Expropriation is that let's say some Indian companies, they made an investment to Azerbaijan, let's say $500 million, and there are some events happening. We expropriate. Expropriate means we terminate that company's existence in our country, and we say them, okay, bye bye guys. So that's what expropriation. And in the event of expropriation, of course they need to be compensation, because those guys, they're like invested $500 million in your country. Of course you need to pay for it, right? And so that, and you let them go. In this case, you need to pay for it. So that's when we are talking about the compensation issues here. The final one is the dispute settlement mechanisms such as ISDS. Like, what is dispute settlement mechanisms? Like, of course, there are like dozens of investment disputes, and how do we deal with them? So in this case, we need a dispute settlement mechanisms. Mostly the parties, they are going to arbitration. Yeah, like international arbitration institutions. So so that's our dispute settlement mechanisms. Okay, so once we're talking about foreign direct investment, one of the important matters is the incentives. What are the incentives for the foreign investors? Of course, the most attractive one for the foreign investors are tax, because business is about money, right? So they want to get more money and they want to pay less money. And here we have the tax holidays, custom exemptions, and land use benefits. So let's say governments or states mostly choose some specific areas of investment that you say, okay, if you do this kind of, let's say, EV, right, the electronic vehicle. So am I clear? Can everyone hear me?
Yes.
Oh, okay. Thanks.
Yes.
Uh, Thanks. So we say that okay, you bring electronic vehicles to my country, and I want to use less gas, oil, or something. So you will pay less tax in these specific types of investments, and also custom exemptions. We can use this example as well. Let's say you are, I'm sorry, you are bringing the like electronic devices. We want to like improve that sector in our country, and there will be custom exemptions. And also land use benefits. For example, you are investing to um, specifically fertile countries such as Ukraine. I don't know, yes, Ukraine, and they say, okay, we will improve the like agriculture in our country, and they give some um, like there is some specific rights to the foreign investors who is trying to do agricultural business in their country. So that can be the land use benefits. So this is the material part of the material and the interest part of the our issue. But we also need to take a look at to the legal side. Um, we already talked about expropriation, and of course, the countries they can't just say, okay, Azerbaijan tells India that okay, wow, like you should make $500 million investment into my country, and they come, they do, and once Azerbaijan has everything they want, they say Indian company that okay, like you terminate me like we need to terminate the contract, like you violated this terms, these regulations, this international agreement, these local laws. So that's when we need the protection from unlawful expropriation. So of course, like we need legal protection for the foreign investors. And in this case, of course, we need the international institutions and international arbitrations. Maybe the country, India or Azerbaijan, they have their own arbitral institutions, but it's better for the both sides that if they go to the like neutral part, which is international arbitration. And of course, the non-discriminatory treatment, which we already talked about, like the most favored nation treatment and the national treatment issues. I will be continuing. What are the
Yes.
challenges? Yeah, thanks. What are the challenges for the countries in FTI regulations? So when it comes to foreign direct investment, the we can see that there are different definitions to the foreign investor. Like, let's say you can go to the Indian market as an investor from China, and you can be considered as foreign investor. But with your same company, you can go to Mongolia, you cannot be considered as foreign investor. But your what you do, nature of your business, and your form of your nature of your legal persona, it didn't change. So there are different definitions for the foreign investors in different countries. So the investors need to be attentive when they are trying to when they are going into to invest in one country, because they need to have the lawyers. They need to make a legal research beforehand going to invest in the other countries. Of course, the other matter is here is that increasing protectionism. What is that, you may say? Let's say there are mobile companies in China and there are mobile companies in India, right? And India sees that, okay, if I import all the mobile devices from China, let's say in our case, let's say they are cheaper or they are like their system is better or something. And India sees that, okay, local manufacturers, they cannot make profit, right? All the money goes to the Chinese companies. So they start to change the regulations into the local for in favor of local investors. that's actually a big trend right now. All the countries, they are trying to make their in local investment law um, better and the worse at the same time. Like better in terms of okay, they if they need to improve one field, they make better regulations, like attractive regulations for the foreign investors. But when they don't want the others come to go into that business, they say okay, like we need to be more protective. And it's actually the continuance of this case that delays in regulatory approvals, lack of transparency in dispute resolution. It's always about the interests of the parties, and when they have, and like it's they're always their legal uh, their regulations, and maybe hard for the registration and or the taxation and the custom issues. So the foreign investors, they don't want to go into that market because they're like okay, their lawyers say them that okay, if I go there, there will be more problems for me. The situation, like the regulations, is hard to deal with there in that country. Also, the lack of transparency in dispute resolution, which means that the countries, let's say Indian company comes to invest in Azerbaijan, their lawyers see that okay, there is not much dispute resolution methods in Azerbaijan. There is no arbitration. There is no mediation. There are only courts, and they will probably do something for their own the party. So they are not trustworthy. So that can also happen. So if the investor sees that that's an actual issue, they avoid to invest that country. Let's continue. How the dispute resolution works in FDI. Uh, what dispute resolution mechanisms we have is we have here the famous ones actually are ICSID, the International Center for the Settlement of the investment disputes, and also the UNCITRAL. The UNCITRAL is the United States Commission on International Trade Law, and also ad hoc tribunals. Like ad hoc tribunals, ad hoc means like ad hoc is the one of the forms in recognition international law. One is de facto, the second is de jure, and the third is ad hoc. Ad hoc means they are making their tribunals just for that case. It only applies for that case. So that's what we call the ad hoc tribunals. I would like to mention the investment cases. One is Yukos versus Russia. It's like big energy investment dispute happened between Yukos company and the Russian Federation. And the other one is Philip Morris versus Uruguay and Australia. And they're mostly about the investment, like energy investment disputes. And as I know, both awarded in favor of the companies, not the countries, the investors, not the companies. Now we will see what we have. So in conclusion, foreign direct investment is vital for economic integration. So if you have lots of foreign investors, it means your economy will grow faster in a time being. But also it have some downsides because you all kind of give your some part of some part control of one issue to other people in your country. That's from the government side, but when we look at the investor sides, you just go into other country and other state, and you make investment, you make profit, and you also have some big risks, but you also hope to be make not hope, you are aiming to make a profit. And also the strong balanced legal frameworks attract sustainable investment. Definitely, like if you have good legal framework and well done legal framework, and the investors will see that okay, that's trustworthy, so I could go there. That will be all. Thank you so much for your attention. Yeah, I'm ready for the questions and answers if there are one. I will
That was a
stop
great
sharing.
presentation, Nijat. I would like to invite the audience to put forward any questions if they want. I guess we have a question for you, Nijat, in the chat box from Mr. Nirangshu Debarma. Yeah. So can you read it, or would you like Tia to read it for you? Ms. Bajpai.
I guess I'll just read it out. So the question that Mirangshu has asked is, if a country provides funds to another nation for the development of a specific sector, but the receiving country diverts the funds for other purposes, so what consequences are there?
Um, when we are talking about the foreign direct investment, we are not saying that, let's say, one country gives money to others to come to improve that. No, you are a businessman, right? And you have a company, and you are specialized in one term, and you say that, okay, I am good. I have money. I will come to do this in your country, and so we will make profit together. So that's what foreign direct investment about. The countries need someone to come to, let's say, build an establishment, build an infrastructure. Let's say you are. Let me give you an example. I have a construction company, right? And I'm investor from China. I have a construction company, and my target country is Azerbaijan. And I tell Azerbaijan government that I will build you roads, right? And after building those roads, I will employ, let's say, 2,000 people in your country, and later I will uh, get the profit from that roads for 30 years. So what we have here, the country, the state has new good roads, and 3,000 people of his population got new jobs. But what I got is that I built that job road, and later I make it paid road, and I get my money. So that's the logic of the foreign direct investment. I hope that's clear.
Anyone else? If you have any questions, you may just raise your hand and speak straight. I guess we had a
I
question
think
from.
Prabhati Dalai has a question.
You may speak, Prabhati. Yeah, Prabhati, you may unmute yourself and speak. Is it fine, Prabhati? Okay. I guess we have an issue. Fine, no issues. Anyone else you have any questions? You may simply raise your hands. Shravya Vemu, I guess you were raising your hand during when Najat was speaking. So do you still have the question? Okay, no questions out there. Good to go. Okay, Nijat, I had a small question as a
Please.
startup consultant. So
Yeah,
let's
please.
assume that a venture capital firm based in US wants to invest in a startup based in Azerbaijan. So what would
Okay.
be the FDI, procedures, general FDI procedures?
So general FTI procedure. Thank you so much for the question. The general FTI procedures is like, we have an example here, right? And first, you need to, you are an investor from your side. You need to make a research about the market. How's the market there, and how is the market working? Because in the end, you want to get the money, right? The second, you go to the investment law of the country. In terms of Azerbaijan, which is called the Law on Investment Activities, which has accepted in 2022, July 22. And you see the regulations. What are the incentives for the foreign investors? Let's say there are national treatment, there are like most favored nation treatment. There are always the list of the countries that they encourage the investors to come. In the case of Azerbaijan, it's green energy, for example. That's actually green energy and artificial intelligence. So you see that, okay, your business is in the positive list, so there will be tax incentives for you, and also there will be the subsidies for you in the future and everything. So you go there. But when it comes to actual procedure, like, okay, you see that, okay, law is okay and the market is okay. What you need to do, you either you can open your company's branch there. That's one of the forms. Or you can open the another company, like an independent company, or you can buy the shares of the one company. After buying that, you will register in the um, it's called the state tax service. They will register you as an investor and as a company, and then you can do the market, and they will give your taxes, and that will be it all.
Okay, that's great, Nijat. Thank you for the response. I guess we have another question from Yasin. Ms. Bajpai, would you
Sure.
like to read it?
Should I tell you? Oh my God, let me see.
So the question is, should FDI involve the transfer of money or technological transfer among countries could also be considered as FDI?
Um, Thank you so much for the question. Thanks for the reading. When we are talking about FDI, we always talk about the money transfer, and we always talk about some. It's not goods transferring. Like, I give you the technology, you pay for it. It's a sales of goods. It's not a foreign direct investment. For foreign direct investment, you always need to have the. In the end, you always need to have new company or branch of the company. So, like, we in terms of the technologies, you have technology and you want to take it to another country, and you invest money to the country, and you open a company in that country, and you take your technology there, and in that case you pay for the customs and all the intellectual property rights issues, all the investment and all the tax issues that comes up. So when we are talking about the FDI, we always talking about the money. My pleasure. Thanks for the question.
That's great, Nijat. I guess you can carry out from here, Ms. Bajpai.
Thanks so much.
Okay.
I wish rest of the speakers good luck. Thank you.
Thank you so much for the amazing speech, Mr. Nijat. It was really interesting. And please share your
Thank
email address in the chat box. So if any of our audience has any questions or seeks further information, they can reach out to you. Next, we have Mr. Gaurav Joshi, and I request him to comment the speech.
Yes, hello everyone. Yes, it's a great pleasure connecting with you all guys over this platform, and thank you to SK and Associates for organizing this conference and allowing us to put our opinions forward. It is well said, since sharing your knowledge with others will always improvise the community and the education. So I'll be presenting on the aspects of IP mostly, and how it is important for business considerations. So I'll be sharing my screen on. Just give me a moment. Is my screen visible?
Yes.
Yeah, it is visible.
So before sharing, from the aspect of IP, I would like to mention that randomly my friend asked me one day that uh, I requested him that you should protect your IP, you should protect your brand name. So he replied me that what's in a name? So I told him that for business, it's everything. Your brand name, your logo, your identity are not just symbols. They are valuable assets, and it should be protected under trademarks or say copyright or say patents. Since imagine someone stealing your brand name reputation overnight. Scary, right? Let's talk about how to prevent that. So this IP strategic plan is all about how to protect your IP and how to protect saving your business if someone else steals by copying your brand name or stealing your IP, stealing your patent, stealing your copyrights for which you have already secured registration. Just give me a moment, I'll reshare my screen. Yes. So the why it is important to protect your IP. So you're launching a business, you're launching a startup, you're launching a company. The first thing you decide is your brand name. The first thing you decide is what technology you are going to use. The first thing you are going to decide is what sort of creative work you will be generating in that business and which will be distributed in the public domain. So there are several aspects which are covered under IP. That is, first is trademark, second is patents, third one is copyrights, and the fourth one is designs. So let's say what are trademarks? So if you decide a name of your business, then you have to protect it. Reason for protecting is you don't want someone else to copy the brand name and use your goodwill to generate the revenues in the market. So that is very important. Consider Coca-Cola, consider Nestle, consider Apple, consider Nike. They have protected their brand names not just in India but in globally overseas in each and every country just to safeguard their well-known status in the market. With respect to patents, similarly, they have protected all their invention, their all technological ideas which they have launched in the market. Since if you don't protect your IP, eventually there will be some other person who will come with the same idea, and he or she will start selling that product in the market under that particular brand name or selling that technology. Copyrights, considering copyrights, it is very important. If you launch a book, you launch a music, you launch a creative work, uh, it may be artistic work, a cinematographic film, or let's say a software code. So you have to protect it anyhow. You don't want someone else to copy in the market and sell it in his or her name. Designs are aesthetic appearances of a product. Consider a mobile phone. The 3D aspects of that mobile phone will be covered under designs. So it is very important you protect under the Design Act. Each and every we have treaties between nations under which we can internationally protect our IPs, and we can individually protect the IPs in the respective countries wherein you are launching the particular per se trademark, patents, copyright, designs, anything. So, considering from the perspective of India, there are several steps which are for protecting your IP. You can file an application before the Indian Patent or Trademark Office, and then you have a particular time span. Let's say it approximately takes 1 year to register your IP. So you can file a trademark application, your patent application, your copyright application, or a design application. Similarly, if you have an intent to launch your business in the international domain per se, you are considering USA or uh, European countries or African countries, then you have a particular IP office in each domain wherein you can file your applications to protect your IP. So for patents, we have a patent corporation treaty, or for trademarks, we have a Madrid protocol system wherein under you can designate a particular application into a particular country. Suppose you are an Indian applicant, you can file through these treaties into a particular nation and several other at the same time. So these treaties give you eventually advantage of filing multiple applications to protect your IP at one time. However, you have other option of protecting filing your IP individually also in each nations. And the third aspect is very important, that is first to file rule. So there are countries wherein if you don't protect or file your IP at first, then there will be some other person who knows about your company, your well-known status. he or she will file the application in that particular jurisdiction and will secure registration. So reason being it, and thereafter you come after 1 year that no, this is my particular brand name which you have registered in this particular jurisdiction and I want to file. You don't have the right. You lost your rights at the moment when the first application was filed by a bad faith registrant who is selling or providing those services under that IP. So it is very important to understand that you, as and when you launch your product in the market, you protect your IP. Since if you lose your IP, your business will, you will lose your business, you will lose revenues in the market, you will lose everything. So IP is very important aspect, being a growing law also, and being a important aspect from the business of launching your business and generating business in the market. It is very important. So suppose you got to know that there is some other person who is selling a product which is similar to that of yours under the same brand name, which you have already protected in your jurisdiction, which for which you are already selling products in the market since last 10 years, and there is some other person who has come into market and selling a similar and providing a similar goods or services under a brand name, or providing a sort of technology for which you have already patented, or selling a book which for which you are the rightful owner and the author, but you got to know that someone else is selling that book in the market. So you have enforcement actions, you have strategies through which you can enforce your rights in the enforce your rights in the appropriate tribunal or the courts, and you can get injunctions from there. So for in case someone files a similar trademark application or a copyright application or a patent application, then in that case you have options of filing oppositions, cancellation proceedings against those bad faith applicants or registrants. So you can file an application before the tribunals or the appropriate courts, and you can get injunction from there. And you also have civil remedies and criminal remedies. Per se, in India we have civil and criminal remedies. Also we have these remedies available in other courts of different jurisdictions, per se USA, Europe, African countries, or etc. So you have these remedies wherein you can seizure or counterfeit those goods which are by bad faith registrants in the market, and you can stop those persons from selling the products in the market by using these enforcement actions. There are instances wherein you get to know that someone else have registered with a similar domain name in the market, and this is also called cyber spotting cases, wherein a party is under similar domain name providing similar sort of goods and services, and the normal human being is getting spoofed because of these domain name bad faith domain name registrants. So you can take action against those as a part. It is a part of IP, and it is considered that you can send them notices, or you can appear before the tribunals asking to take criminal or civil actions for such instances. Before moving to this case law, which is a recent case law, which for which a decision has been passed by Honorable Delhi High Court, India, wherein the brand Amazon was selling counterfeit good. Can you imagine Amazon selling a counterfeit good on e-commerce platform, which was Beverly Hills Polo Club t-shirts? So this is a particular brand name, Beverly Hills Polo Club, and their t-shirts were being sold by Amazon without authorization or without license. And since 2015 to 2020, these goods were being sold by Amazon without authorization, without licensing. The plaintiff filed the suit in the court, and they got a injunction for 39 million US dollars for contributing this infringement case. So you can imagine how it can go against you if you do not if you follow such infringement actions, if you follow such bad faith practices in the market. It can go against you. Court can issue injunctions, and you can mess with hefty damages and fines by the court. So this is one of the leading case, which is a set example that how it is important to protect your IP and to take enforcement action, since the other party took enforcement action against such a big company and got a injunction for 39 million US dollars, which was asked them to pay immediately within the month of within 3 months, or interest will be charged thereafter. So recently, I was working with one of the clients. So this is an example. Uh, if you know that China is a market for counterfeit goods, you receive counterfeit goods from China directly, and it is exported to India, and we people of common intelligence don't even understand that whether this is a counterfeit good or not. They use it, they apply it, they eat it, or they use it for the purpose of industry, and the outcome is that you realize at the later stage that this is not the quality good which I was expecting for from the company. It is not the mistake of the company, it is the counterfeit good which you have received from the manufacture bad faith manufacturers in China, who are selling you these products who are exporting these products in India, and there are sellers who purchase it from China and they sell it in the market of India. So it becomes very important for us. At that moment, the client came up to us and he said that I want to stop this export of goods, counterfeit goods from China to India. So what we did was we took another enforcement action. We went up to the customs, the China customs, and therein we recorded these registered IP. We already had registered these IP in China. We went to the customs and we showed them these registration certificates of our IP, and eventually within 2 months, those counterfeit goods were held by the China customs, and we were informed of those, and we have taken action against those parties who were exporting those counterfeit goods, and the China state appellate board has also taken action against them. So anyhow, these enforcement actions have helped us a lot, and we are planning to advise all the clients in India, the big clients, to first protect their IP and then launch their products in the market, just to safeguard at the same time. Next come is that how you can monetize your IP. See, if you have a registered IP, you can uh, sell your IP, you can assign your IP, you can license your IP, you can franchise your IP. You would have seen many companies like McDonald's. So these are all franchise. You would have seen Apple stores. So these are all franchises which have been licensed by Apple to those sellers in the market who are selling products of Apple. So you can generate revenue, your personal revenue, by franchising the IP, by licensing, like Disney licenses characters for merchandise. So this is a very good example. Royalties, you can earn royalties. Suppose you have a registered patent, so you can license that technology to other parties in the market, and then you can earn from that by charging them royalties. So same as you can do IP as collaterals, you can secure loans by using these IPs and patents, trademark, copyrights. So specifically for the startups or new ventures coming up in India, the government has provided benefits. First, all startups and MSMEs, you have a 50% uh, discount in the government fees. You can file your IP applications all over India, and you don't even have to pay professional fees in some cases, wherein the law firms or the attorneys are already registered with the Startup India schemes or with the government of India. So you get 80% fee concession for startups. You have a fast track examination for patents as well as for trademarks, and the CGPDTM is the Controller General Patent and Trademark Design Trademark Office, which is India. So for subsidiaries for IP filings under MSME, you can, if you are a registered MSME, you can file applications, file Form 28 for startup fee waiver. You can waive off the both professional fees and government fees. If a company is being established under startup or MSME, you can waive off both the fees. The government fee is waived off by 50%. However, the professional fee can be fully waived off. So you have technology in innovation support centers for IP guidance. You can take guidance from them before you protect your IP or you file a patent. legal person can contact the department and they can seek guidance. So you have to take proactive legal measures also. If you have a registered IP, if you are a big company, you must be having a IP which turns out to be in lakhs or crores. So what you have to do is you have to do time to time IP audits and monitoring that your IP is protected, whether the patents, copyrights, trademark are renewed from time to time. You have to do a Google alert, trademark watch, track infringement. This is like you have to check from time to time whether there's some other party who is infringing our brand names, who is infringing our copyright, who is infringing our technology, per se patents, or any designs which we have. Suppose I am a distillery company, I have a packaging bottle under which I am selling a bottle. So you have to check from time to time, is there to confirm whether there is no company in the market who is selling with a similar design of the bottle packaging. And if you find someone who is doing such bad faith actions in the market, then you can send them cease and desist notices. You can send them DMCA notice, takedown notices for copyright. Custom recordals means, as I told you, that a record, if you are importing or exporting your goods in other countries, then you have to protect your IP by registering them at the customs, since goods gets transferred through customs via consignment. So you have to contact the particular custom offices. You have to protect your IP by recording these IP with the particular jurisdictions and their customs. So that's it. Thank you so much. So at last, I would like to submit that IP is not just a legal asset; it's a business tool. Protecting it ensures competitive edge, revenue streams, and obviously brand integrity also increases. Yes. Thank you so much. So you are not audible, sir.
Yeah. So that was a great speech of Mr. Joshi,
Thank you
especially
so much.
this last part. I also am hearing it for the first time. So I guess we can file multiple intellectually, what do you call that? Trademarks at the same time, right? That is what you said.
Yeah.
Okay, I was not aware of that. So thanks. Yeah. Now I would like to invite all the participants to put forth their questions, if any.
Sure. I would welcome your questions, please.
Anyone who has questions may just raise your hands. No questions. Okay. I have a small question, Joshiji.
Yes, please.
When we speak of circumvention in competition law, okay, so a fundraising, assuming that a client actually signs an agreement, a startup signs an agreement with a CA, agreeing to be connected with investors via the CA, chartered accountant, and there's a non-circumvention clause in the agreement saying that if they actually breach this entire thing by directly reaching out to the investor later on and putting the CA aside as a consultant, so there would be a penalty of 4 times of the fees that they had to normally pay the CA as his consulting charges. So is it like valid, and
The
to what
question comes in
extent?
that through whom did you got connected with the other party? If the CA was the party with through whom you got to
So let's
connected with that
assume we
investor.
have an investor and we have a startup. So the startup is
Hmm.
getting connected to this investor via the
Hmm.
CA, and the
Via the
CA
CA.
has a contract with the client saying that there's a non-circumvention policy which says that if you directly go to the investor bypassing the CA, so you will be charged with a penalty of like 4 times the consulting charges you were supposed to pay the CA. So is that contract valid? And if it is valid, in what, until what extent is it valid?
I don't
As
think the
per the
contract is valid, since considering that there are only two parties who are involved in this agreement. If only two parties have executed that agreement, that is the investor and the startup, then in that case this clause is not valid.
no,
If
no,
there are three,
agreement is between the CA and the client. The startup, the
Oh, if
CA
it
and
is
the
between
startup.
the CA and the client, then this clause is valid. This clause is definitely valid.
Okay, so non-circumvention is valid, right?
Yes.
Okay, thank you. Okay. Any other questions from the audience? Harshit, Oshin? Yeah, we have a question from Harshit Gautam in the chat box.
Who
Joshi.
monitors IP use and misuse in our organization? So it depends from organization to organizations. There are companies who have their specific IP team. So they from time to time they check in the Google search. They check whether their trademarks are not being misused by any third parties. So it is a timely check from we consider 1 month, 2 month, 3 month, quarterly, or half yearly. So they check it from time to time, and we do have a software, but those are specifically used by big companies or law firms to check or monitor whether there is infringement in the market with respect to any trademark, patents, copyright. So yes, you can check it through those softwares as well. Mm,
Okay, we have another question
government
from
body
Yasmin.
doesn't monitor any malpractices with respect to IP, but they only monitor if you file an application during the examination stage. If the examiner gets to know that there is already a similar application with a similar brand name or similar patent or similar design being filed, then in that case they won't allow you to register your IP. But they do not monitor if there is any malpractices in the market. So you have to do it on your own. Selling a Bisleri and selling a Bilseri, there is a difference. You're welcome.
That's great. Last question, Mr. Joshi, if I'm not already getting on your nerves.
Yes, yes, definitely.
Let's assume we have a edtech startup which has the trademark for its name, the company name that has got it had got a perfect trademark from the government of India. So in case the edtech startup actually creates a lot of YouTube videos, and later on someone actually tries to copy or cut a clip part of the video and use it with their brand name. So will the videos created by this edtech startup be classified as an intellectual property in accordance with the trademark of their company name that is registered and the logo of their company which is there in the video?
Definitely. So, firstly, with respect to copyright, saying you your rights are created from the moment the copyright is generated. So as of now, if I am recording a video, if I am talking to you in this virtual call, and if this is being recorded, then my rights sustain and I am the speaker on this. So without my authorization, no one can use my content in any domain without either your authorization, since I am authorizing you to use my video, or by my authorization. So if someone else uses that particular work or that video content for his or her bad faith purpose, then in that case it is definitely a copyright infringement. You don't need to and also for copyright you don't need to secure registration specifically. That registration certificate is only a statutory document which you show to the court that I have a registered copyright. Even though you have copyright rights, the moment the work is created, so when the video was created, the copyright rights you got on it. So there is no iota that someone else can use your content and use in the market. It is totally copyright infringement. And if you are using your trademark on that particular video, suppose you are using SK and Associates on your video on the left corner of the video content, then in that case it becomes a action of trademark infringement as well. So both the rights you sustain on that infringement case, that is trademark and copyrights both. And it is very advantageous in the case of copyright that you can directly take criminal actions. You can directly file a police complaint. However, not in the case of same in the case of trademark. So you have those rights in the copyright. I hope that is clear.
That's great. Now, if any of the audience still has any questions, you can simply raise your hand and speak. Or else, if you're feeling shy, you can just drop a message even. Yeah,
I don't think
we cannot.
you guys should feel shy for asking questions. It should be
So actually,
straightforward.
people do We even had a client once who was into
So I
trading
have a
company in
question. What's
Northeast.
the cost and timeline for IP registration in India internationally? Should we register IP before pitching to investors or client? Uh, I'll go with the first one. That is, what is the cost and timeline for IP registration in India? So it depends upon the category of the company. If you or the individual, if you are an individual, the cost for registering uh, IP for trademark per se, it is 4,500. For a private limited company which is registered under a startup or MSME, it is 4,500. If you are not registered under startup or MSME, the fee multiplies by 2, that is 9,000. It becomes 9,000. So there are different categories under IP wherein you file the application. For trademarks, there are different classes as per your business, your goods you are selling in the market under the brand name. Internationally, I won't be able to give you the cost right now. It depends from attorney to attorney how much they charges. It is usually in US dollars, but for I can tell you for few of the countries like in US, it is around 350 USD for filing one single application for trademark. Uh, and it differs from office to office of each intellectual office of each jurisdiction. And with respect to the second one, should we register IP before? Addition to first one, don't compare the cost of filing an application in India with that of US. In India, it would be around 15 to 20,000, including professional fees. However, in US, it may go around 2.5 lakh to 3 lakh rupees, registering just a trademark. And I'm not talking about patents, it goes around 5 to 10 lakh rupees. So should we register IP before pitching to investors or client? Definitely. The moment you are starting to launch your business, you are starting to launch a product, or you are launching a service in the market, you protect your IP first. You just file an application. I'm not saying you protect your IP, you file the application. Filing an application makes aware the third parties in the market that yes, I have the trademark rights now, I have the copyright rights, I can take action against you if you feels to do any sort of infringement in the market. So yes, before approaching to investors, and it apprehends your business as well, that yes, I have my IP protected, I have my brand protected in the market. It can get you good investors, definitely.
Okay.
So I guess the question is clarified.
So, any other questions from the audience we have yet? Are we good enough to go? Okay, I guess that's it. So,
Yeah.
thank you for the wonderful speech, Mr. Joshi, firstly. And I
Yes.
would like to
Yes.
request you to just share your email ID in the chat box so that if anyone has any queries, they can straight away reach out to you. Yeah. Ms. Bashkar, would you like to take
Uh,
over? Sure.
yeah. Now, as we come to the close of this remarkable conference, we would like to express our heartfelt appreciation to each and every one of you. The knowledge shared, the insights gained, and the connections made have all contributed to the success of this event. We are truly, truly grateful for your participation. As we wrap up this conference, we kindly request all attendees and speakers to take a moment to provide their valuable feedback and reviews on Google Meet. Your input and thoughts are highly appreciated as they help us improve our future events and to continue delivering high quality conferences. Thank you for your participation and for being an integral part of this remarkable conference. We look forward to your reviews and hope to see you all at conference 4.4 tomorrow as well. Until we meet next time, stay inspired, keep dreaming, and continue to strive for excellence. Thank you all and farewell for now.
Thank you so much. Take care. Bye bye.
Thank you, participants. We shall meet tomorrow for the second session. Have a great day.
Yes, thank you so much.